All right, ladies and gentlemen, welcome to a lecture on criminal justice, sociology 327. We're just going to get right into it. We're going to go 1, 2, 3 for our first three introduction sort of chapter breakdowns. Okay, so this is all going to happen in one. All right, so the general overview of experiences with the criminal justice system. Many people have direct or indirect experiences, right, with it, right? We know this. Stories of crime and justice can seem really interesting to the public due to it being an important part of justice, and most of our idea of crime, however, is influenced by the media. All right, just a quick little intro. Let's get into this, right? So, all right. What are the three major agencies of the Canadian justice system? We have the police, the courts, and the correctional system, right? The police enforce and prevent crime. The courts adjudicate crime and move forward with legal proceedings. And the correctional system punishes and rehabilitates offenders, right? We looked at three cases. The Jakansky case. Essentially, dude shows up in an airport. He's acting aggressively. He gets subdued and then tasered 45 times and dies. RCMP is confronted about it. They testify. They're told not to collaborate on testimony. They do. Their testimony showed otherwise to what was actually recorded to have happened. So this is an issue regarding the police. We have the Pouchy case. Pouchy was responsible for the death of his children. Decided to venture into the cold with his inadequately dressed kids who died of hypothermia. A sentencing circle was used to determine adequate sentencing, which was monitored to assure an appropriate conclusion. So, a lot of people weren't happy with that. But this relates to the courts. And then we have the Smith case. Smith committed suicide by strangulation in a correctional facility while the guards just watched. The guards were told that extraction of prisoners from their cells looked poorly in reports, as their usually required force. So the guards thought that the suicide attempt was kind of just a grab at attention due to the nature of the facility and recorded. This is about the correctional system, right? So again, the three major agencies, the police, the courts, and the correctional system. What is a crime, right? How do we define that? There are a bunch of different definitions, right? It can be pretty complicated. There's the legal definition, the social definition, the constructionist definition. We'll get into all of that. So, the legal definition. There are two commonly used legal definitions of crime. What are these? It is that a crime occurs when a law is broken, and a crime only takes place when a person has been deemed guilty of a crime and punishment accordingly. And punished accordingly, right? So, again, the legal definition of crime. A law is to be broken, and a person has to be deemed guilty and punished, right? The issues with this definition, not every individual that violates the law is caught and punished. Many crimes are unprosecuted, even if identified by authorities, and there is no analysis about why some acts are dealt with formally and others informally. Two, we have the social definition, right? This defines crime as a violation of social values, and it views crime as causing injury socially or harming others. As such, it should be controlled. Right, so the social definition, right, mostly just a violation of norms causing social harm or injury. And then we have the constructionist definition. Some sociologists contest the existence and clarity of norms with regards to the social definition. They also question the utility of the approaches that neglect the reality that norms vary across time and place. So, constructionists maintain that crime is the result of social interaction. It's a negotiated process among the police and the crown prosecutors, right? So we have the legal interpretation, right? Essentially just a violation of the law and a following punishment. The social definition, a violation of norms that causes social injury or harm, and the constructionist definition, which maintains that crime is the result of social interaction, being a negotiated process regarding the definition between the police and the crown prosecutors. With regards to it being a negotiated process, it leads into this idea that criminal behavior is not always self-evident as it might expect to be, right? So Raymond and Leighton did a study, and they found that most Americans have admitted to engaging in crime, but there exists class and racial bias in the administration of crime. Only certain individuals are arrested and prosecuted, revealing that negotiated aspects that there are negotiated aspects of identifying crime, right? So kind of leading into this constructionist definition is this negotiated process, right? This bias, this class identification system. Um, yeah. So, moving on, is the criminal justice system fair? Can the system simultaneously promote liberty and security? And does the state and the criminal justice system possess similarities to organized crime rings? Well, let's get into it, right? So, the criminal justice system has three main objectives: controlling crime, preventing crime, and maintaining justice. Justice meaning fairness or equality. Um, yeah, so it also looks at rehabilitation and punishment, right? There's a debate over placing low-risk offenders in correctional treatment, and there's a debate over crime prevention strategies, right? The criminal justice system spends a lot of time exploring ways to reduce crime rather than simply punishing offenders. But again, the three main objectives it has: controlling crime, preventing crime, and maintaining justice. What is criminal justice, right? The concept of criminal justice is abstract, right? It's contentious. Many Canadians adhere to the justice model of criminal justice, which we'll get into much later. Essentially, guilt, innocence, and sentences should be administered fairly with the available evidence. The punishment should fit the crime, and like cases should be treated alike, and different cases differently, right? And we'll get into that much more later in our later chapters. The second point, right? It's going to be looking more at the criminal code, different types of law, classifications of crime, and a little bit of the police, right? So, introduction 2, right? Let's get into it. So, what are the types of law? There's public law, right, governing rules for fairness in society between individuals, including criminal law, and then we have private law or civil law concerning relationships between people. Let's look at the criminal code, okay? So it's incredibly dynamic, right? It's not static, it's constantly evolving. We've seen changes in prostitution laws over time, right? In 2013, we decided that selling sex is not illegal. Essentially, everything regarding prostitution is illegal except for the woman doing it, right? To kind of take some of that illegality off the woman, right? Some facts about the criminal code. It's over 1,100 pages. It was first enacted in 1892. It is a federal statute that is frequently amended to reflect legal and societal changes, even being updated to address cyber threat. There are problems with how frequently it's updated. For example, the McCann case in 2010 might have resulted in a mistrial given that the judge used a provision that had been struck down. This is important, right? If something's being changed so consistently, it leaves the judges to have to stay up to date with that, and so sometimes they might not be able to do that to the best of their ability. We also still see, some discrepancies here. We still see laws prohibiting witchcraft, water skiing after dark, whatever it may be. So it is not static, and that can lead to some issues. There's some pros and some cons. Another note, laws reflect societal belief about crime, right? Unfortunately, many impulsive or youthful offenses happen without much thought regarding consequences. Harsh sentences, as opposed to the likelihood of punishment, is only effective in a world where people carefully weigh the consequences before committing a crime, right? Just another important note. But yeah, criminal code, not static, constantly evolving. 1,100 pages, first enacted 1892, federal statute that's frequently amended to reflect legal and societal changes. Classifying crime, right? How do we do that? Well, we can do it in different ways, right? We can look at categories based on seriousness of the crime. We can kind of look at the differences in the ways that that we divide crime, and we can also look at hybrid offenses as part of that. Let's cook. So, categorization based on the seriousness of the crime, right? We have mala prohibita, which is crime or an action prohibited by law but not necessarily wrong, right? And then we have mala in se. These are acts considered evil, immoral, and wrong in and of themselves. So again, categorizing crime based on seriousness, we have mala prohibita, right? It is prohibited, but not necessarily wrong. And mala in se, it's considered evil, immoral, and wrong. How do we differentiate different crimes in the criminal code? We have summary offenses, which can carry a jail sentence up to 2 years and a $5,000 fine, and indictable offenses, which can result in life imprisonment. just a second here. Let's just take a look at this. Just a later chapter. Sorry, feel free to skip forward just a little bit as I look for what I'm looking for here. Okay. Yes, this is where we were. Okay. Summary conviction offenses carry imprisonment up to 6 months and a maximum fine of $5,000. Not 2 years. Yeah. Sorry, just to recap what we talked about just in this specific section. Classifying crime, right? Mala prohibita and mala in se. Prohibita being prohibited but not necessarily wrong, and in se being acts wrong in and of themselves. Summary offenses: jail sentence up to 6 months and $5,000. Not as serious, and then indictable offenses, which are potential life imprisonment. Then we have hybrid offenses. Essentially, the Crown Prosecutor, through police collaboration and evidence, can decide, depending on the details of a case in certain situations, if a case will move forward as a summary or indictable offense. The police, right? There are different levels of policing, right? There's federal, provincial, and municipal. Naturally, federal is responsible for federal law. Provincial manages the administration of justice on a provincial level and responsible for things like healthcare, transportation, education, whatever it may be. Municipality, with regards to policing, right, they pass bylaws to regulate local issues. In 2015, there were almost 70,000 sworn police officers in Canada in total, right? Let's look at the courts. So, the courts, right? What's it based in? Canadian courts are based in English common law. It's kind of an adversarial system where it's two parties working against each other, and it's kind of a winner-takes-all thing. What's some other information here? We have the Supreme Court, which is the final authority, the Provincial Court of Appeals, which reviews decisions from the Superior and Provincial Court. We have the Provincial Superior Courts, which handle serious crimes, and the Provincial Court, which deal with less serious offenses and manage the highest volume, often called assembly line justice, due to its progression. Right. So, just to reiterate that the Supreme Court is the highest court of appeal and the final authority. Below that is the Provincial Court of Appeals, right, reviewing decisions from the Superior and Provincial Courts. Then we have the Provincial Superior Court, which handles indictable offenses, and the Provincial Court, which handles summary offenses. There are a few more levels, but it's not too important. A little more focused on the adversarial system, right? The prosecutor and defendant both aim to win. The trial is heard by an impartial fact finder, the judge. R.V. Stinchcomb ensures this was a case, and it ensures that evidence is disclosed to both parties mandatorily, right? The R in RV, a case, represents Regina or Rex, meaning the queen or the king, and the V represents versus, essentially. It kind of means and, right? The defense counsel represents the accused, while the crown attorney or prosecutor represents the state in the case, right? Let's move forward. Discretion, right? Discretion in our judicial system. It's essentially the freedom to decide what should be done in a particular situation. It allows the system to function efficiently and effectively, given the law enforcement cannot possibly arrest or prosecute every single offender. Key actors in our system have decision-making flexibility, right? Judges have discretion, cops have discretion. The challenges to this, especially for cops, is distinguishing between fair discretion and discrimination, right? Yeah. Some incarceration statistics. You know, 37,000 adults and 1,000 youths are incarcerated daily into correctional facilities. There's 110,000 around serving alternative sentences that are more community-based. Let's see, just jurisdiction based on sentencing severity, right? This is an important note. Offenders may be incarcerated in provincial or federal institutions depending on the seriousness of the crime. Federal institutions see sentences over 2 years, like indictable offenses, and provincial institutions see lesser sentences, right? Like summary offenses or misdemeanors. Many offenders don't fully complete their sentence. They benefit from parole or statutory release, and this is done by intention. All right, that is our introduction 1 and 2. Just a reminder, so far, what have we talked about? We talked about the major agencies of the criminal justice system, right? The police, courts, and correctional facilities. We talked about the different definitions of crime, right? Legal, social, and constructionist. We talked about the purpose of the criminal justice system through control, preventing crime, and maintaining justice. Some justice model principles. We looked at, what else did we look at here? We looked at public law and private law, mala prohibitum, mala in se, summary offenses, indictable offenses, and hybrid offenses, and the nature of the court system, right? The hierarchy of it, the adversarial system of it, and then some incarceration and correctional facility statistics. Now finally, introduction 3, the final piece of our introduction for criminology here. So, there's a funnel in criminal justice, and we'll talk about this. Essentially, how it works is we get a total amount of charges made, and then from that point forward, we get a total amount of cases that are proceeded with from those charges. We get a total amount of people that are found guilty from those cases, a total amount of people that are put in provincial custody from those found guilty, and then only a certain amount of those people that are in provincial custody are federally imprisoned. Yeah, so that's essentially how the funnel works, all right? We start with a lot of charges, and then through case, through guilt, through provincial custody, and federal imprisonment, we get to less and less people that eventually end up in prison. Yeah, right, so only 6% of people make it from the start to the end. Filtering occurs at each stage, yeah. So, what are some sources of discretion? As we talked about that, and we'll continue to do so in the criminal justice system, right? Victims don't have to report crimes, right? That's an area of discretion, right? They might not. Why? The incident was deemed unimportant. They don't think the police can help. Yeah, could be too personal, whatever it may be. Police also have discretion. They execute discretion in deciding to lay charges. Cases may be dismissed or unfounded or minor, right? As unfounded or minor. Almost half of all criminal suspects were not processed to the next stage of the funnel, even when the police believed that the crime had been perpetrated. For example, sometimes the Crown Prosecutor doesn't consider it worth it to go through the full court proceedings in cases where the defendant is clearly going to win or get off easy. Court can be expensive, so sometimes that isn't worth it, depending on rare cases, and we'll talk about that more. Bail hearings. This is another area of discretion, right? Judge can use a bail hearing. Bail is a temporary release from jail for a defendant awaiting trial in exchange for security. It usually requires money to make the exchange, right? Evidence has shown that those denied bail hearings are much less likely to be acquitted and more likely to be found guilty, and those denied bail are also more likely to incur longer prison sentences. So, bail hearings are important. A judge's discretion in allowing bail hearings can be important. The prosecution, right? It's another area. There's discretion in laying charges, right? The time between the laying of the arrest and when the prosecution decides to proceed generates the greatest amount of contrition in the criminal justice system, right? This is where we lose the most amount of people in the funnel. So, charges can be stayed for a multitude of reasons, right? Insufficient evidence, victims' unwillingness to testify, deals between police and the accused. Sentencing, again, that's another area of discretion, right? Sentencing decisions can be influenced by extra legal factors, such as the accused characteristics. For example, Indigenous people in Canada, First Nations people, are disproportionately sentenced to imprisonment compared to white folk. So what have we talked about so far? The nature of the crime funnel, right? Total charges to cases to guilt to provincial custody to imprisonment. And then the sources of discretion, right? Victims, police, bail hearings, prosecution, sentencing through the judges. Yeah, let's talk about the criminal justice system models for a little bit, right? We have two major ones. We have the crime control model and the due process model. Herbert Packer developed these two contrasting models. So, the crime control model, the focus is control and suppression of criminal activity, emphasizing speed, efficiency, and incarceration. It operates on the presumption of guilt and represents a get tough on crime philosophy, while the due process model focuses on the protection of suspects' rights. It ensures fairness at every stage to prevent wrongful convictions by the protection of the rights, and it operates on the presumption of innocence as opposed to guilt, emphasizing the necessity of safeguarding individuals from systemic errors. Yeah, um, that is it. Right. So, most important things there: the funnel, the discretionary nature, right? Victims, police, bail hearings, prosecution, sentencing, and the two models that we look at here, right? The crime control model and due process model. That is our intro, our full introduction to criminal law. Sorry, criminal justice.